If you guys are confused by copyright, particularly when you write a song with somebody else, then this video is for you. So when two or more people come together and they share lyrically, melodically, or some hook, beat, or groove, then what's called a joint work is formed. And under United States copyright law, a joint work basically means that each party is going to automatically own an equal share of that composition. In other words, the whole composition, not just the part that you wrote. So if you wrote the music and somebody else writes the lyrics, it's not that you own the music and they own the lyrics. You both own an equal share of the entire song. And the metaphor is kind of like if you were to take an egg and you were to scramble an egg, you can't remove the white and the yellow and separate them. They are inseparable. Okay, so when you write a song with someone, you are owning a share of the entire song. Now, if you want the splits to be different than what the United States copyright law says as the default, then it needs to be in writing. And typically what people do is they put it in what's called a split sheet, and they indicate the names, the name of the song, publishing company, splits of the song, etc. And then you take that sheet of paper and you put it away somewhere in a file, and you hope that you never have to pull it out, because if you pull it out, it probably means you guys have some sort of dispute. Okay? Typically, most people are professional in negotiating those rates. I mean, if I come together with you and I write a song with you and I really legitimately only put 20%, into the song, then essentially you get 80 and I get 20, right? And we agreed to that. And the reason why I would agree to that is because I want to continue to work with you and I want my reputation in the industry to be good. So, this isn't a time to be greedy, okay? Now let's talk about the control of that work. Each party has the individual right to issue as many non-exclusive licenses as they want, as long as they account to the other writers and they give the people their share of the composition. So you could go off and you can put the song in a Taco Bell commercial for $4,000 as long as I get my $2,000 and you acknowledge that I actually was a writer on the song. Not that you'd necessarily want to do that, because there are some tax implications, right? So typically what would happen also is that Taco Bell would seek out licenses from each one of us individually. That's probably more likely what would happen. But in any case, there needs to be an agreement about how the song is going to be used as well, because that can cause lots of conflicts down the line. You might want to use it in a porn. I don't want it to be used in a porn. You might want to put it on your record first. I want to put it on my record first. So that also needs to be decided. My name is Bobby Boyd, helping musicians turn their art into more successful business. Peace.